This account begins with the property, the creek, and the governing context. I am Dale Brennan, 58, living on my grandfather William Brennan's 2-acre tract in what became Willowbrook Estates, Colorado. 400 yards of Cottonwood Creek cross the parcel, and our documented water rights date to 1873, senior to later claims and predating statehood. William, a combat engineer, shaped the channel with granite placements, meanders, and gravel beds that functioned as natural flood control features. Over time, the pasture changed. Willowbrook grew to 47 homes with high valuations and a formal homeowners association. Martha, my spouse, teaches 4th grade. Our adult children live elsewhere. I keep a motorcycle workshop on the property. The parcel predates the HOA by roughly 80 years and carries deeded exemptions, including mineral and water rights and protection from later development restrictions. Those facts became important once the association tried to apply aesthetic covenants and asserted jurisdiction beyond its reach.
HOA President Brenda Hartwell, 52, a real estate professional from Marin County, owns a house backing to the creek.
Her board pursued uniformity standards typical of new subdivisions. My property retained lawful uses consistent with the original deed. The creek, those rights, and the association's governance would soon intersect. This documentary moves from the first violation notice through hydrology disputes, regulatory review, and ends with restoration work. The first conflict concerned aesthetics and jurisdiction. I received a certified HOA violation alleging unsightly storage of automotive parts, accessible at $200 per day until compliance. My certified reply explained that my parcel predates the association by roughly 80 years and carries deeded exemptions, including mineral and senior water rights, making the covenants inapplicable. A meeting in Brenda Hartwell's office did not resolve the matter. She pressed uniform standards, while I reiterated the limits of HOA authority over a grandfathered property. Anonymous county complaints followed, asserting illegal business operations because my motorcycle workshop appeared commercial. County inspectors spent about 2 hours reviewing the shop and found no unlawful activity. Responding required counsel, and I incurred about $1,200 in legal fees to document compliance. These steps illustrated a pattern: pressure through aesthetic rules and administrative channels to compel conformity beyond the reach of governing documents. Meanwhile, the creek and runoff became the new focus. Rather than continuing appearance citations, the association engaged outside counsel to frame a hydrology risk affecting downstream homes. That pivot introduced claims about flow, erosion, and flooding and attempted to shift studies onto me. The subsequent filing relied on historical mapping rather than current surveys, setting the stage for rebuttal using modern data, applicable water law, and documented channel performance across multiple seasons. The association's legal strategy advanced through counsel at Peaton and Associates, who filed a nuisance water flow complaint asserting my property created dangerous runoff threatening downstream homes and requiring a $50,000 environmental impact study. The filing drew on watershed maps from 1967, predating interstate construction, later subdivisions, and modern storm infrastructure that altered the valley's hydrology. I contacted Pete Morrison at the Colorado Water Authority. He identified the mapping as obsolete and cited current surveys showing my reach functions as natural retention. Boulder placements and meanders reduce velocity, disperse energy, and promote infiltration during high water. Colorado's prior appropriation doctrine also framed the analysis. Our documented use from 1873 confers senior rights relative to later claimants, including the subdivision. Over a weekend, I assembled William Brennan's engineering notes, recent county surveys, and field measurements, then filed a counter requesting that the HOA fund a proper assessment because their complaint relied on outdated data. The record showed that far from adding risk, the natural channel reduced downstream impacts by storing and slowing runoff. That record, together with seniority of the water right, answered the central allegations. The issue moved to county review, where updated evidence, lawful priority, and channel behavior would be evaluated. The arguments had shifted from aesthetics to hydrology, emphasizing data, sources, and the consequences of using superseded base maps. County authorities reviewed the filings, surveys, and historical documentation and ruled entirely in my favor. They ordered the Homeowners Association to cease water-related harassment and recognize the validity of my historical senior rights. The decision confirmed that the association's nuisance theory rested on obsolete mapping, and that the natural channel on my property operated as beneficial retention. A local newspaper summarized the outcome, drawing attention to governance issues residents had been experiencing. Citations for mailboxes, garden decorations, and exterior paint. Those accounts were not part of my matter, but they illustrated the climate in which the board pursued enforcement. Although the ruling should have ended the dispute, the association leadership escalated. President Brenda Hartwell scheduled an emergency meeting and advanced a proposal for concrete channeling presented as flood mitigation. The project was promoted with images of erosion and the authority of a consultant who, according to disclosures, was a relative's landscaping contractor rather than an independent hydrologist. The plan shifted the controversy from legal priority to physical alteration of the creek itself. From that point, the case moved toward heavy equipment invoices and regulatory oversight, because the proposed work implicated permitting at the county, state, and federal levels. Those layers would determine scope, timing, and the legality of channel modification. While Martha and I were out of town, the board held an emergency meeting. The notice went to an old address, limiting our ability to respond. At the meeting, photographs depicting erosion were presented, and a consultant described immediate concrete channeling as necessary flood protection. The consultant was a relative's landscaping contractor, rather than an independent hydrologist. The motion passed 6-1 with Edwin Kowalski opposing. Homeowners were assessed $1,800 each toward a project totaling $127,000. Upon returning, we found the creek transformed into an 18-inch concrete trough. Granite placements my grandfather installed were buried, and spawning areas that had existed for generations were destroyed. I documented conditions systematically, photographs from fixed points, velocity observations, and water samples for comparison. The contractor was Pinnacle Construction, a company with prior EPA violations for unauthorized waterway modifications and a tendency to start work before permits. Each element pointed in the same direction: a significant alteration of a natural channel undertaken without demonstrating legal authority or technical necessity. The association's emergency rationale rested on contested visuals rather than current hydrological studies. Those facts shaped the next steps, which moved beyond HOA correspondence to regulatory complaints, agency investigations, and a restoration plan grounded in historical documentation and modern surveys of Cottonwood Creek and its observed seasonal performance. Substantial modification of a natural waterway typically requires layered approvals: county permits, state environmental authorization, and, where applicable, federal clearance under the Clean Water Act. The concrete trough was installed without those approvals. Potential exposure included federal penalties of $25,000 per day and state penalties of $10,000 per day while violations persisted. I filed complaints with County Code Enforcement, the State Environmental Agency, and the EPA's Region 8 office in Denver. In parallel, I contacted Trout Unlimited, which offered support because spawning habitat had been destroyed. Within roughly 10 days, multiple agencies opened investigations, and an environmental law clinic at the University of Colorado offered representation. Regulatory questions centered on jurisdiction, permitting status, and whether the project increased downstream risk. Meanwhile, the association leadership discussed expanding concrete channeling from the roadway to the subdivision boundary. That proposed expansion heightened stakes and timelines because additional work, would compound unpermitted impacts and complicate later restoration. My role shifted from responding to HOA correspondence to coordinating evidentiary materials, permit records, contractor histories, photographs, measurements, and historical engineering notes. Those materials provided a common record for agencies assessing compliance and for counsel preparing claims and potential injunctive relief. The investigation phase marked a transition from neighborhood disagreement to enforcement, with technical findings and documentary proof guiding the next procedural steps. Financial review illuminated a parallel track. Sarah Olivia, a law student conducting forensic accounting, examined HOA records and vendor relationships. She identified inflated contracts and non-competitive approvals linked to Brenda Hartwell's business network. Of the $127,000 assessed for the concrete job, documentation supported roughly $40,000 in actual construction value, with the remainder labeled consulting and emergency premiums routed through related entities, including Hartwell Property Consulting and Willowbrook Environmental Solutions. Patterns extended beyond this project to prior landscaping, security, and legal engagements over 3 years. Those findings indicated potential civil liability for the board and raised questions associated with racketeering exposure. Concurrently, neighbor Edwin Kowalski's recording of a board meeting captured strategic intent, using association resources to pressure out residents deemed incompatible with the leadership's preferred vision. Taken together, the financial trail and the recorded meeting aligned with the timeline of the concrete decision, the emergency framing, and the special assessment. The record intersected with hydrology concerns because money approved without competitive review, funded work that removed natural retention, and concentrated flow toward downstream homes. The combined evidence became part of referrals to investigators and informed counsel's structuring of claims. The result was a case theory: environmental violations, financial irregularities, and governance misuse reinforcing one another and supporting requests for restitution, compliance orders, and attorney fees. Engineering analysis explained why the concrete channel increased risk. Natural channel design disperses energy across a wider floodplain, with boulders and meanders storing water and lowering peak velocities. The new trough concentrated flow, elevated velocity, and directed water toward downstream foundations. William Brennan's 1973 report, prepared for the county, warned that concrete channeling at this location would triple downstream flooding during heavy runoff years. Modern modeling by Dr. Angela Rodriguez at Colorado State confirmed the conclusion, estimating roughly a 400% increase in risk under peak conditions. Topography was central. My property sits naturally higher, while subdivision homes occupy the traditional overflow area identified in historical surveys. Using grandfather's flowcharts, recent measurements, and seasonal weather projections indicating heavy snowpack and a wet spring, I calculated likely performance under peak melt scenarios. The results aligned with both the 1973 analysis and the modern simulations. The project did not merely lack permits. It created the hazard it claimed to prevent by removing retention features and narrowing conveyance. Those findings informed requests for emergency relief, restoration requirements, and the evidentiary narrative linking design choices to foreseeable outcomes. They also provided clear criteria for remediation: reestablish meanders, restore boulder placements, rebuild spawning beds, and return the creek to a stable, natural channel geometry, proven to reduce downstream impact and verified by field observation. During the investigations, escalation took the form of offers, threats, and property damage. Brenda Hartwell presented a $500,000 cashier's check, with a non-disclosure agreement requiring relocation and transfer of my water rights. I recorded the meeting, which included statements about reputational and economic consequences. A subsequent offer for $750,000 arrived with broader restrictions and similar threats, and that meeting was recorded as well under Colorado's single-party consent rule. In parallel, my workshop was vandalized twice. Vintage motorcycle parts were scattered, tools taken, and my restored 1972 Sportster tipped and contaminated. New security cameras captured a white Tesla with distinctive vanity plates near my driveway during night activity. Anonymous online reviews targeted Martha's tutoring, and her principal received concerns about her employment because of alleged activism. Each incident was documented and added to the evidentiary record for law enforcement and for civil claims. Taken together, the offers, vandalism, and reputational pressure fit the timeline of regulatory exposure and growing board liability. The pattern supported causes of action beyond environmental counts, including intentional infliction of emotional distress and related civil remedies tied to coercive conduct. The documentation also reinforced credibility in agency proceedings because the recordings and videos were time-stamped and corroborated by independent events on the regulatory calendar. Those materials were preserved in formats for evidentiary integrity. Institutional proceedings expanded as evidence accumulated. The EPA opened a formal case. The Colorado Attorney General initiated an investigation, and the FBI, led by Agent Lisa Park, examined suspected white-collar fraud linked to HOA contracting. EPA criminal enforcement, through Agent Tom Rodriguez, pursued environmental offenses associated with unauthorized channel modification. Pro bono counsel Kate Morrison, from the University of Colorado Legal Clinic, organized 4 tracks: Clean Water Act violations, state water rights infringement and permit fraud, county code and special assessment improprieties, and civil claims for fraud, conspiracy, racketeering, and intentional infliction of emotional distress. Community support coalesced into the Cottonwood Creek Redemption Project, with contributions from Colorado Trout Unlimited, the Sierra Club, local businesses, veterans, and residents. Media coverage grew, including regional reporting and documentary interest, while communications highlighted environmental restoration rather than personalities. Technically, Dr. Rodriguez's modeling and William Brennan's photographs anchored a restoration plan, budgeted near $35,000, supplemented by committed third-party funding. As snowmelt accelerated, several HOA board members resigned and insurers queried the subdivision about unauthorized drainage changes that could affect coverage. My tasks included coordinating records for agencies, preserving chain of custody for digital files, and maintaining comparable measurement points along the altered reach. The litigation strategy emphasized contemporaneous data, dated sources, and credible experts, so that each thread, environmental, financial, and governance, could stand independently and reinforce the whole in court. Flood conditions and litigation converged. Flash flood watches escalated as Cottonwood Creek ran between 150 and 200% of normal. During this period, Brenda sought an emergency restraining order alleging surveillance and threats. The hearing coincided with peak runoff. In federal court before Judge Martha Blackwood, Kate Morrison presented recordings of offers and threats, and the board meeting audio. Dr. Angela Rodriguez testified using real-time monitoring and modeling, indicating that the concrete channel posed an imminent foundation hazard under current flows. During a recess, the National Weather Service issued a flash flood emergency for the valley. Reports documented water entering Willowbrook basements while my upstream, naturally elevated property remained dry, matching earlier analyses. Enforcement actions unfolded in parallel. FBI warrants for financial records, EPA site control for potential crime scene preservation, and state investigators reviewing HOA financial management. After testimony, the court ruled in my favor. Findings included Clean Water Act violations, infringement of state water rights, fraud, conspiracy, and intentional infliction of emotional distress. Orders required immediate removal of concrete, full creek restoration, and damages totaling $750,000, including attorney fees and punitive components. The judgment also articulated a framework protecting senior water rights against HOA overreach, supplying guidance for similarly situated owners. The ruling linked evidence to outcomes: obsolete maps, unpermitted construction, increased risk. Financial irregularities and coercive tactics led to liability and mandated remediation. 6 months after the ruling, the creek was restored to a natural channel. Where the trough had constrained water, meanders now dispersed flow. Native willows and wildflowers stabilized banks, and trout returned to spawn in rebuilt gravel beds. The work combined contractors, students, volunteers, and former HOA participants. The award of $750,000 covered restoration and legal costs, and funded the William Brennan Environmental Engineering Scholarship at Colorado State University. The first recipient, Sarah Olivia, completed law school and joined the EPA. Accountability followed. Brenda Hartwell pleaded guilty to federal fraud, received 18 months in minimum security, 3 years of probation, restitution obligations, and permanent loss of her real estate license. The concrete company owner received 2 years and $2 million in environmental fines. 3 former board members received probation, and community service focused on waterway restoration. Edwin Kowalski was elected HOA president and implemented bylaws requiring environmental review before projects affecting natural waterways. The case informed policy. State legislation nicknamed Dale's Law strengthened protections against HOA overreach and mandated environmental studies before altering waterways. Law schools and agencies adopted the matter as a case study, and the Cottonwood Creek Redemption Project became a replicable model. My workshop returned to motorcycles and mentoring. Martha integrated watershed civics into classroom practice. The neighborhood shifted from rule-driven conformity toward stewardship, culminating in a creek festival gathering residents and students. The documentary ends with rights honored, restoration completed, and a community organized around protecting a resource older than the subdivision.